All right. Hi, this is Curt,
And Brad Pinsky,
and we're here for another edition of Fire Law Roundup for May
ninth.
19th of 2025. Brad, go ahead. All
Okay,
right.
so I like when you do this. Sunday night, you're obviously bored. So instead of setting just
No,
one
it's
additional
not
case,
board. It's how much stuff got, how many important cases came down toward the end of last week, or at least
right.
I became aware of them toward the end of last week. And I was thinking about it. I was flying home from Paris. I had a 30-hour day
Oof,
on Friday, right? Because it's
right?
6 hours, so
Yeah.
basically 30 hours, and I spent an awful lot of time. We flew into JFK, and we had a car service take us back to Providence, and what a nightmare getting out of New York City on a
Oh,
Friday afternoon.
yeah.
So there was, I think it was 7 hours on the plane and 5 hours in the car, plus the waiting around time. So I had a lot of time, and those cases, plus several of the people it sent emails to me telling me about the cases. So I don't
Well,
want
we're
to
gonna cover
don't
them.
want to
We're gonna
gloss over.
cover them.
But
So
I
I
know
and
it
I
dumps a lot on you. I'm sorry.
no, no, no. I like it. I don't mind. I don't care. And what I try to do for those who've been watching us for a couple of years now know I try to summarize into a lesson, right? So let's start with, I guess it's mine. Oyster
Yep.
Bay Fire Department. This is a fire department in Nassau County, New York, Long Island. And the short of it is, it was my case actually. I guess I'm on a good string recently because every other week I'm getting another good decision. There's a couple more I'm still hoping for and waiting for. In any event, but in this case, a firefighter had been repeatedly disciplined and under the bylaws of the fire department and ultimately sued because they claimed, oh, you suspended me improperly, and it's in retaliation for an FDNY 9/11 or other disability I have. And on the other side, the department claimed that no, it was because you threatened people, you threatened women, you threatened violence, you did all these things. But
Mhm.
here's the lesson. There's two lessons in this one, and I've got lessons for the other four as well, or all of these today as well. The first thing is when he sued, he went to the newspaper. He went to the big newspaper downstate and wanted to make his case all known. Well, now you lost. So how well is that going to work for you? So my lesson for people is maybe you shouldn't go to the newspaper all so quickly until you're positive you're going to win. And I'm not going to say which case, but I have another case going on now, which we just submitted papers for yesterday or a couple days ago, and we'll have a decision, I think, in the next month. It'll be a big case. But there, the attorney went to the newspaper and said, this is a slam dunk, no chance of us losing. And I'm putting that a 90 some odd percent chance of losing. So, you shouldn't taint yourself. That's my one thing. The second
Well,
thing legally that this case, and then I'll move on, is important for is he it got dismissed for a couple of reasons, but primarily because he did what's called failing to exhaust his administrative remedies. The bylaws said if you are unhappy with a suspension, you have the right to appeal and you have 4 days to, file a notice of appeal and get an appeal. He didn't do that, and that cost him this suit. Whether it was right or wrong and everything else didn't
why
matter.
not though? Why? I mean, why didn't he? That was one of the, as I was reading the case, that was one of the, why not? Why?
I don't know. He
Yeah.
just started sending all these self-serving letters. I can't get into his mind.
Yeah.
I don't know why he didn't appeal properly. He certainly knew the process. He had the bylaws, but everyone should understand if you're in a volunteer corporation, and this is true even under a CBA, but unions are better about this. Um, if you have a process that's provided for in the bylaws or a policy and you don't follow it, it doesn't matter how good or bad your lawsuit is, it's getting dismissed. You have to exhaust your administrative remedies. You have to go through the entire process, usually before you can go to court. There's some rare exceptions, like where it'd be totally futile or, where they're biased or prejudiced, whatever. But in here, it didn't apply. So he messed that up procedurally, and I caught it that he messed it up. These are things lawyers do. We look at the required process, see if you went through it. I caught it and we got it dismissed. So
Well,
kudos
I,
to the
I,
judge.
I see this as a regular issue in union departments because like you said, if if you're being disciplined and you don't grieve it, you don't go through the process, you try to go right to court, you're going to have a problem. So you've got to exhaust those administrative remedies. Volunteer career doesn't matter.
Doesn't
You
matter.
got to exhaust the administrative remedies.
Right. And a CBA is literally a contract, but the
Right.
law holds that the bylaws are a contract between the organization and the member. So you have to adhere to a contract. You got to follow it.
Mhm.
It's important. Okay. Next, let's go to Acron, Ohio, which I think is the home of Akron Brass, right? Maybe, or is that Buffalo? There's an Akron Buffalo too. I don't know. There's a couple of them. Sorry, I figured In any event, we have a Frank Ricky or Ricci situation. We have a white fire captain has filed suit alleging that he was passed over for a promotion to district chief in favor of a younger black female who he alleges was less qualified. So, it's interesting. We've had former suits. Was it LA where the fire chief says, no more old white guys right now? Hopefully that type of thing isn't here. I don't know what the facts are. I'm just saying it's very interesting because the reverse discrimination suits are becoming more prevalent. And what people will see, people sometimes think, oh, judges, whoever appoints them doesn't matter. It does matter. And if this went before a Biden appointee versus a new Trump appointee or former Trump appointee, it does matter which way judges lean. Every judge has views in politics that maybe they're not supposed to, but here you could have.
They don't.
Yeah,
they say they don't, but
they say don't. They're not supposed to, right? They're without belief or bias. Anyway, so here we have a good reverse discrimination case. So I think that was really interesting. And again, we've had one of these.
Yeah, my data is about 3-1 right now. About 3-1. So three minority protected class members to one majority alleging reverse discrimination. Right now, that's how the numbers are shaking out. It was 2-1 for a little while. Right now, it's about 3-1. It's not that don't read into it that they're going down. It's not that they're going down. It's just that the numbers that I had over time tend to smooth out and get to where they should be. I agree with you. They are going up. But the overall data right now is about 3-1.
Okay. All right. So, anyway, again, we've seen this case go all the way to the U.S. Supreme Court, this type of case. Okay. Massachusetts. Interesting. We have a fire chief, I should say, former fire chief. His name is Chris Tobin. I don't know him, but he has now filed a wrongful termination and a whistleblower suit. He came from Florida, I think, Naples, Florida, and he was hired in January of 24. He was terminated about 1 year later, and he claims that it's because he brought legal concerns to the attention of the fire district or the Board of Fire Commissioners or however they're known. And if that's true, then that could be a big problem for the district, right? Or on the other hand, I've seen so many different responses. He didn't keep things and this is not him. I'm giving you examples of what I've seen where they say, well, yes, he brought things to our attention, but the way he did it or his comments or he was unprofessional but usually what you see, and Curt, I think you'll tell me I'm right, but let's see. Usually what you see is, no, it had nothing to do with anything he brought to our attention. He was racist or bad for business or bad for the community. It's always something else that seems to come up. But termination of a fire chief who you've recruited and vetted and hired after 1 year, especially when you don't see like the union going nuts, like we want him gone or anything. This is a little strange. I mean,
I think he was, if I recall correctly, he was placed on administrative leave in August. So really they're talking about a relatively shorter period of time. Or maybe he came back. I'm not sure the whole time frame here, but it's tough. And guidance to chiefs when you come into an organization and you see some concerns. What do you do? I mean, you don't want to alienate the people that just hired you, but at the same time, you don't want to conceal what's
exactly
the problem is. So
there's a way to do it, right? There's probably maybe a tactful way to do it. Again, I don't know either the players, I don't know whether the board, and I don't know who's right. God bless you. I don't know who's right or wrong, but tact matters. And look, if what he said is true, right? And I don't take that to be, toned any sort of way. If what he said is true, Obviously, he's going to have a long, I don't know whether he's contract or not, but damages are going to be an interesting question because he's not just going to get back pay, right? The question is, how long does he get future pay? And that'll be a settlement. But
Well, and harm to reputation too. Someone who's got, like yourself or
yeah.
myself, you have a reputation, and certainly being dismissed in the way it was can hurt the reputation. So in addition to any of that, there's also reputational damage. So
Yep. Yep. So, money's not insignificant, especially when he was probably, being paid 200,000 or so, 160 to 250. I don't know. Okay. Then this is big. I feel like there was a big gap with us though, because we covered this when the allegations were made. We're in FDNY. There was an allegation by, as I recall it, and I'm jumping news stories to the related story, but as I recall it, there were some other chiefs who were accused of maybe assisting or what this chief was accused of.
There's two of them. Yeah. And
Okay.
the other one already pled guilty. I'm not sure if we covered it, but he
I don't-
pled guilty in March.
Okay.
Yeah.
And then there was another related story. Well, let me give them the related story so they know what that we're talking about. So we have FDNY Deputy Chief Antti Sachavino, I think is how I pronounce his name. He was just sentenced to 3 years in federal prison. This is not a small little walk in the park here. And it was proven, right, that he had involvement in a bribery scheme where he would fast track building inspections in Fire Prevention Bureau. So he's going to pay $150,000 in fines, another $57,000 of income. He's got a forfeit that he got from the scheme, which is good. But I also seem to recall, Curt, that there were some lower firefighters who made this claim. We covered it about a year ago, I think, and maybe who made this claim saying they wanted us to become part of the scheme, but we refused, so we got disciplined. I don't remember, but I know we covered this on our show, and it had a neat kind of side. But that was a big scheme, right? People claim, it's proven that he's putting some projects ahead of others. If you pay to play, don't do that. Don't do that. You're going to jail. Lastly, on our scattered list, it's not on yours, but I just want to let everyone know with 15 minutes to go, the state of New York Attorney General appealed my case, the Seventh Circuit case in Ball versus State of New York. And I celebrated as an attorney who's going to be working with me said or asked, he's like, have you ever celebrated anyone appealing one of your cases? I'm like, no, but this one I'm celebrating. Let him appeal. We need this to keep going up to protect everybody's constitutional rights. Okay, so that was good news.
So that's the due process case that we covered. Was it last week? 2 weeks ago, I think.
2 weeks ago, yeah.
2 weeks ago.
Which said that
we jumped over one, the Colorado case.
Oh, did I? Hold on, let me go back.
Yeah. Yep. The Upper Pine River Fire Protection.
Oh, yeah. Look at that. Okay. So we have state firefighter. This is big. This is big. Okay. I have so many notes on this. So we have 2 firefighters plus the Firefighters Association who attempted or did to bring a local IFF in, and they claim that they were fired for union protected activities, bringing in or attempting to bring in the union. If that's true, those are bad things to do and big money penalties. The courts are not, are in no way will justify those types of terminations and they better have good records. I don't know what happened, right? We don't know. It's an allegation, but that fire department better have pretty darn good records about why they happened to terminate 2 people. And the close in time question is always the one that haunts you. Yeah, right. And that question, so the viewers know, is okay, you filed your card saying you want an election for a union on this date, and on this date you're terminated or whatever it is, right? And if it's close in time and you've been a firefighter for 10 years, 5 years, 50 years, and with no big disciplinary history, you're done. If that's what's on the fire side.
I think if this was a private sector case,
NLRA, okay.
The National Labor Relations Act would apply, and the municipality would be in trouble, I think, on the private sector. Now, public sector, each state has its own collective bargaining laws for municipalities and counties and state employees. So it's really going to turn. I'm not familiar with Colorado's version of the collective bargaining laws. But
They cite it in the
also,
complaint. I thought it was
yeah.
favorable to them.
I
I
tend to
just
think it would be. I tend to think typically they say that, you cannot be retaliated against for engaging in concerted activities, including forming unions and organizing and that type of thing. So
yeah.
it's not carte blanche, it doesn't provide you with any sort of immunity protection from every possible thing that you could do wrong. One way folks kind of run afoul of it is doing things basically in the workplace when you're supposed to be working, that type of thing. So, but
Right.
nonetheless, the retaliation part of this is kind of concerning
For the fire department,
for the
definitely.
fire
Yeah.
department. Yeah. Yeah.
Okay, now let's get into our kind of meat and
All right.
potatoes part. Like I said, you get a 5 for or a 6 for here.
Yeah.
So we have a federal court who just in Massachusetts just approved a Fair Labor Standards Act settlement. I'll go through it, but what's important in this case is what they did wrong, because we could literally hit replay to the 20 other times we've had this exact same conversation. And what's getting me is we know who's not watching, right? We clearly know who's not watching our show, because we have said, or attending your classes where you teach all of this at nausea, right?
Yeah.
So what happened was we have a settlement. There's 118 Brookline firefighters. By the way, Brookline, Massachusetts, beautiful area. I believe that's where the governor's mansion is.
Tom Brady's mansion, I believe, was in there.
Oh, also there. Okay, good. No, this is a very nice area. In any event, but the allegation was you didn't pay us overtime, and we could delete the headline, delete who that is, and we could plug this in a million times. So once again, everyone, here's what they did. They claim, and this is basically the settlement paid them everything. So I assume their claims were agreed to, right? Although confidentially, so to speak. But they failed to count all hours worked, failed to include all required wage components. The second part, which I'll cover in detail, is really very common, right? So they had I think an active shooter pay, out of class assignments. I'm going to skip one for a moment, and some contractual overtime, some COVID overtime. Listen, if your people are working extra hours, right, is lesson number one. You got to count them right, they're either, if they're included in your, whatever pay period, number of hours, fine. But once you exceed 52, 53, or whatever hours you do, depending on your 128 hour, whatever pay week, you darn well better pay overtime. But the biggest problem we see is they're not calculating the base rate properly, and they don't include other stipends that are guaranteed here as well. And this was a active shooter hostile event response stipend, an Asher stipend, and they didn't include it. Again, if you have a guaranteed stipend, like if you're a paramedic, you get this, right? Then you have to include that in your base wages. Even if it's $100 a year divided by 52 weeks and come up with the hourly rate, that's what you got to add into their overtime pay. But here's one that I want to ask you about, and we might not know. So that's what they did, right? And they messed up the pay. But part of this says they didn't include shift swaps. That's the part that I'm questioning if anyone even agreed to, because that shouldn't be included, right?
No, and the FLSA has a provision in there that the employer does not have to consider shift swaps. That basically shift swaps are off the table. You just ignore them and you pay them as if the person who is scheduled worked the hours. So yeah, I didn't understand that one either. But again, sometimes the judge isn't all that familiar with the nuances of the fire department version of the FLSA. We're pretty unique. There's really no other profession that has substitutions and things like that. So, but I will tell you one thing that I don't understand. I have some suspicions about was the fact that the firefighters were only paid 21 hours out of a 24-hour shift. I don't understand how that could happen practically. Now, I understand realistically what happens is you have somebody in payroll and they hit the button and it prints out payroll and it prints checks that say basically 21 hours, but it's for an accommodation for the payroll system. But how do you get around those additional 3 hours. If somebody works 24 hours, you have to pay them. Now, there's a couple of exceptions, a sleep exception, meal exception. Generally, firefighters don't qualify for
Right.
those. It's certainly in a city like Brookline, they wouldn't qualify for those. So again, they ended up having to pay them, or make some sort of a compensation settlement on those hours that they were not properly paid for. But again, I don't understand that part of it. But you and I covered this when the settlement was first announced 3 or 4 months ago. And one of the reasons why I covered it again is because the judge kind of walked everyone through, or walks the reader through, what a court is going to be looking for in these. So if you're a fire department or a payroll person, and you're concerned about how you're doing it, the judge you can read the decision and see how a judge is going to look at these things, because these settlements have to be approved, and the judge can't just say, okay, everybody's in agreement, it's good. The judge has to make an independent evaluation and make sure that the settlement is in line with the FLSA. So that's one of the reasons why I covered this. It's a good example for folks, also for unions. If you're looking at, our compensation systems being properly applied, you can read through the decision and you get a good sense for what a court is going to look at.
And then there was just one little last part to this, not so little for these people, but the deputy chiefs claimed that they were not exempt from overtime. They didn't win and they didn't get anything. They remained classified as exempt. That's always a factual question, right?
It is, yeah.
Whether they are or aren't. It's a legal question to the extent that the elements, how you evaluate, is based on the law, but it's ultimately a factual determination. They were not included.
And I'm assuming those are shift commanders. They may not be, but if they're shift commanders, that's where we see a lot of sort of factual deviations, where one department they're hourly, another department they're exempt, and it like you said, it's very factual. Yeah. So you got to kind of look at their duties, responsibilities, and so on. But in this case, they ended up conceding that. One of the big questions about class actions, and when a union brings an action that includes firefighters but also chiefs, is the majority of people in the union are going to be firefighters, and there might only be 3 or 4 deputies. And part of the settlement is, well, give us the deputies as exempt, and we'll give you yes, all in favor, aye.
Right.
And so now you have a group that is sort of marginalized.
And it's tough because you're a deputy chief. You want to be a leader to your subordinates, and you don't want to screw up the settlement necessarily. Right?
And it's not fair to the deputies to see firefighters walking home at the end of the year with more money than the deputies, because
which is what happens.
Well, it does happen. It does happen. And from a leadership perspective, you want to make sure you don't allow that to happen, because then who's going to be going for your deputy chief spots when they're going to be making less money than captains and battalion chiefs? So,
yep. Okay, let's go to Pennsylvania. And by the way, I just want to pull my hair out, but I want to talk about this for all you I'm not going to say stupid because I don't like that word, crazy people out there. So let me just very quickly say what's happened here. This is just a lawsuit, allegations, but we have a female firefighter. You could take the players out of this, take the state out of it, and I have 2 cases just right now that are the exact same thing, where I sit on opposite sides. But don't do this. So here's what it is. Female firefighters alleged suit in federal court, alleging that the Northampton Township Fire Department retaliated against her and allowed retaliation. And the simple facts are, as far as I'm concerned right now, is that they date, they're in a welcome, consensual relationship. Now, the male is a senior firefighter. Now, I don't think a lieutenant, just a senior firefighter. And some departments have that designation. Sometimes they call them sergeants.
Yep. And I've seen so many complaints like this, including one where a firefighter is referred to in the complaint as a lieutenant because that firefighter acted as a lieutenant once or twice. And I think it's a little bit of intellectual dishonesty on the part of the drafter of the complaint to
Right.
kind
And
of,
it matters. Let's tell
it does
people
matter.
why, right?
Yeah,
It matters because if a officer or a manager or a supervisor
Mhm.
is involved in the discrimination, then the employer is deemed to have known, right? You lose pretty much. But, and this is going to be my point, where it's just a regular person, then that doesn't automatically impute knowledge of what's going on to the employer. So there has to be a complaint. Now, here's the issue, and here's, I could wear my lawyer hat or my defense lawyer hat, and I'm going to put my defense lawyer hat on and my corporate counsel hat on because this stuff pisses me off. So I'll rant for a second. So they have a romantic relationship, right? Apparently wasn't prohibited. And then it goes bad. Like most relationships go bad. And then, so no shock there, right? And then allegedly this senior firefighter is retaliating in some not nice ways. Okay. Put on the employer hat. One, look, I would love to say there will be no in-house romantic relationships. It's prohibited. You are not to date. If you do so, we could terminate both of you, right? That would be my preference. I know it's on the line, but because otherwise you get this.
I think
So
an alternative to that would be it's got to be disclosed, and if you're a ranking officer, you can't have supervisory authority over the person you're having a relationship. You got to get on other shifts and get out from under that control.
which is extremely common, right?
Yeah.
But in a single firehouse fire department, that may be impossible. And
right.
then you start getting into, well, I want overtime, you want overtime, who has the right to the overtime since we can't be on the same shifts. None of this is good. I get it. People get close, right? Romantic, but none of this is good. My problem is we're going to hold the department, they're seeking to hold the department liable because the department does nothing. Now, look, there is an allegation that a complaint was made to the department. But if I'm the department, I'm like, wait a minute. You just engaged in a relationship. It was welcome. You didn't need our help then because it was welcome. We're not going to get involved. All of a sudden, it's not welcome anymore. And now you want us to get involved because your relationship turns bad. At some point, and I'm on the losing side of this when I say this, so don't everyone think this is good legal advice. It's not. But at some point, the employer should be off the hook to say, you know what? You chose to be in a relationship with this person. How should that come back at any point thereafter? How should that come back to, oh, now the employer's got to rein our employee in. You can't act this way to your employer.
The liability is not automatic in this situation. And what has to happen is the department needs to be aware, not of the relationship, but of the, for example, calling the woman in the workplace a psycho stalker, referring to other firefighters, referring to her as the psycho stalker, or other types of things that diminish her reputation, diminish her standing within the department. So I think the department has an obligation, once they are aware that it's going on, to take steps to cut it out. But it's not automatic liability unless that person, as you suggested, is a supervisor. And that is the rub here, because her attorney is going to be trying to make this guy look like he is some sort of a boss, even though at the time he was just a quote unquote senior firefighter.
Right. And that's the harder part, because one of my cases he was a nobody. In fact, the case I have, and I'm not going to say anything because it's public, but she was his boss initially. She takes a normal run-of-the-mill position to get off the board because she couldn't be her own supervisor. He then gets promoted, becomes her boss, right? And you're running timelines. And so the employer's like, well, wait a minute, who's boss and who's liable for who when? And I hate dating in the workplace. I get it. But some of these laws are so unfair to the employer. And yes, you can't, look, no matter what, you can't use a romantic relationship to affect the terms and conditions of employment. That's the end of the story. But I hate just when the employer, and well, let me say this and I'll give you everyone my advice. I hate when the employer becomes liable because the relationship goes bad, right? This could have been the other way. It doesn't matter whether an inferior, a subordinate, can sexually harass a superior. So Absolutely. It doesn't matter how this goes. But here's the thing. You guys should look at policies to stop this. You shouldn't either allow the dating, or you should put restrictions on it and acknowledgments and conditions. And because frankly, this is always going to happen. Relationships end badly, people are immature, and things happen, and nobody dates alone, right? When you're dating someone else in the fire department, everybody knows, everybody's involved, whether they want to be or not. I've been part of that department, a department like that, and some people are uncomfortable, some people, right? Everybody gets involved in some way.
Yeah.
And then when, look, I'm divorced. When you get divorced, you not only split up your assets, you split up your friends. In a firehouse, how do you do that when you both still work there?
Yeah.
Dating is bad.
We could do a class just on romantic relationships in the fire service and some of the
We
things.
probably should,
I know some
frankly.
women that have gotten themselves retaliated against because they basically they develop a reputation for being a home wrecker. They go from this married man to this married man to this married man, and whether the rumors are true or not, the organization, the firefighters react to her in a certain way, and now she's ostracized, and now she's the one that's complaining, hey, there's these rumors going around, none of them are true, but now I'm being accused of this, and now the fire department is stuck trying to, untangle this big, ball of yarn.
Right.
What do we do with it?
Right. And that's my point. Like, are you supposed, as the employer, are you supposed to stay on top of the relationship? Hey, is everybody okay? Anyway,
Yeah.
our laws have gone. Look, I'm not saying that retaliation in the workplace is right. It's never right, period. For whatever reason, even a valid reason, it's not right, right? Bullying, harassment, it shouldn't be present in the firehouse or anywhere. We're there to protect, not to harm, but relationships go badly. I don't know. Anyway, but please, if you can, avoid dating, find someone else, right?
Well,
But avoid
let's
dating.
talk about must-have policies. I know one of the ones that I've drafted. I'm not sure if it's
Yep, it's coming
been
out. I know where to
issued
go.
yet, but it gets into the steps that someone needs to take, two parties need to take when they do have that romantic relationship, to help avoid those types of problems. So.
The funny thing is, I pulled that for we're going to escalate that because so
Yeah.
I'll be doing a video shortly. Okay, so let's go to wow, we have a $15 million settlement reached in a fatal helicopter crash against the maintainer of the aircraft, and we should. You make a note at the end of this, which is so right, which is, these helicopters are picking up either with a Bambi bucket or directly. They're flying low, picking up water, driving over a heavy smoke and turbulent winds, right? We are beating the crud out of these helicopters for things they're partially meant to do. And if they're not maintained better than perfect, this is what happens. We have a death. And so we have the family of a helicopter pilot who died, and they were assisting with wildfire suppression. And they now have a $15 million settlement by the maintainer of the helicopter. The hydraulic system failed. He called that there was a problem with the hydraulic system. The government determined there was a problem with the hydraulic system. So they paid the settlement. 15 million is, I assume they had, I assume obviously as your wife, I'm guessing there might have been kids. 15 million is a lot. And I'm assuming that this was a younger, not older person, because when you do calculations, right, it's what loss of earning do you have? What loss of consortium do you have where you could have helped your family out? What's going to cost them to replace you on the services you provide? 15 million is a lot, a lot. I mean, we're 1/3 of Kobe Bryant's case. Right. So that's a lot of money. So impressive lawyering, by the way, I would say. Okay. So, and then we've covered this, haven't we? We're going to go to New Orleans. I feel like we've covered this a couple of times in different stages
Yeah,
of
I
this.
think we did. Yeah.
Okay, perfect. So we have a federal court who's now denied a New Orleans fire captain's request to amend the race discrimination suit. The short of it is the judge says there's nothing alleged that's going to change anything in your allegations. This person keeps trying to come up with more things, more facts, but it's a good lesson. I just had a case. One of the cases I think I just won had this in it where the judge says, listen, if you're just trying to manufacture facts to bolster your case and they weren't really alleged, or the facts you allege aren't going to change how I evaluate the law, right? The facts aren't important in the valuation, then we're not going to allow you to do it, and we're going to keep dismissing it. This captain is still proceeding on two disparate treatment claims. He didn't treat me yet. I think it means he had a policy, right, that kind of discriminated against me. But almost everything that this fire captain tried to argue has been rejected, dismissed, etc. And he claims it's a racial discrimination case. Nothing new on that. But I like the procedural part here because I keep seeing it. People keep saying, "Oh well, the judge dismissed our complaint because we didn't allege certain things, and now we're just going to add it in." And the judges take a. It's one thing when you add a new cause of action, a new legal theory based on the facts you pled. It's very different saying, "Oh, now I'm going to add more facts to try to create or support a legal theory." That's very difficult. Some judges, I feel like I'm teaching law, not doing this show, but some judges say, listen, if you want to plead an alternate theory, you can do that based on the same facts. But how do you, it's like saying, well, he was sleeping when I found him, but he might have been awake when I found him. Which is it? All right. I mean, you can't, you discriminated against me based on race because you did these things. Oh, I forgot. There's these 5 more things. Did you forget, or are you manufacturing them? In any event, the facts have to justify and support the law. They didn't here, so the judge didn't allow it. But people need to spend a lot of time when drafting a complaint. People always ask me, why does it take you 20 hours to draft a lawsuit? Because I read it about 100 times without joke. I mean, I write things and read them again, and you look up cases and you look up the loser cases, the winning cases. What did they plead that helped in this situation? What errors did they make? And you got to do this, but not putting out facts is a little fishy, right? That's what judges, I think, okay, if that was such an important fact, how did you overlook that? So no, I'm not going to allow you to add it and go on a witch hunt.
Cool.
And I think that is it for this week.
I think it is. That was a long discussion. You carried the ball for me. I appreciate it.
Well,
And,
you're on like 2 hours sleep. Who knows?
yeah, well, I'm still a little bit jet lagged, but we're getting back to normal. I'm back on a jet tomorrow. I'm headed to Kansas City tomorrow. So,
oh, which Kansas City?
Casey Mo.
They've been in our news radar for a long time. So,
well,
good.
we're going to see what we can do about keeping them out of it. So, all right, and that's going to do it for another edition of Fire Law Roundup. We'll